Okay, so I'm Lucy Garrett, and I'm at a chambers called Keating Chambers, and I specialise in commercial law. Now, the thing that no one tells you about commercial law at university is that it's actually lots of different areas that are based on industry specialisms. So commercial law just really means law relating to commercial business life, and that tends to divide up into construction, which is what I specialise in, something like pure insurance, and banking, and also general sort of commercial transactions. And the type of practice that you have can be quite different depending on which of those industry sectors your particular bit of commercial law specialises in. Key part of what I do is arguing about contracts. Almost all of my cases turn on the particular construction of the particular contract in question. In my industry sector, construction, the parties they like to be inventive and new with their contracts, so they're always changing things around. That's always leading to intellectually interesting and legally interesting arguments about what the contract means. There's also, obviously, if you're doing a particular industry sector, there is industry-specific knowledge that you acquire as part of your commercial practice. In mine, it's very techie knowledge about what goes wrong on construction projects, which include anything from building a road, a bridge, to a big iconic Wembley Stadium or the Shard, to a hospital, to infrastructure, to ships, to nuclear power stations, almost anything. So in every single case I do, there is a different factual and technical set of issues that you have to get on top of. And a feature of commercial law is that for every case, you become an expert in the issues that are in dispute in your case for the duration of that case. So you sort of become an engineer, or you become an insurance specialist on the particular insurance you might be doing for that bit of the case. And one of the things that's so much fun about doing commercial work is that it has this, I think, unique combination of a serious legal, academic, intellectual challenge because of the contract framework to the dispute, plus a factually interesting, different every time issue that you're going to have to become an expert in if you're going to be any good at that particular bit of the job. The clients are obviously as varied as the industries that you're specialising in. Mine are absolutely marvellous sweethearts because they all just build things. It's a lot of fun. People in the commercial clients in the commercial world want to know an answer quickly and practically, and they want their lawyers to be both superb lawyers but also able to carry out quick analysis of the real issues that matter to them, the commercial issues that matter to them, so that you can tell them, well, do this, do that, and not just sit there citing House of Lords cases. So you have to have a combination of really stellar legal ability, but also the ability to slightly forget your law and concentrate on what's practically going to be needed for that particular case. I think that's my 5 minutes up, so I'll...
I think that now means that it's my turn. My name's Anthony Jones, and I'm from 4 New Square Chambers. If Lucy has given us an introduction into pure commercial law, I introduce the impurities into the equation. I think that obviously commercial law is interesting because it's so varied. There's this sort of bedrock of commercial law, which is about the dispute between the two parties on the basis of their contract. And then I think there are 2 other very interesting questions, which is, sure, you've got a dispute, you've got some debt or you've got some judgment in your favour. How do you turn that into something that is tangible? How do you turn that into an asset? How do you enforce that? And then the second interesting thing, I think, is why are you in this dispute? Is it because some professional advisor you had failed to warn you of the problems in the industry, or is it because you thought you were buying something that had a lot of value and then you looked at it afterwards and you realised it was worth a quarter of what you thought? So that's then sends you in the direction of professional liability, which is seeking remedies against the people you thought were going to help you. And my practice is less of the pure dispute work and more of these two ancillary areas. How do you turn your debt into something that matters by sort of para-chancery things of turning it into real property, etc. And then how do you seek remedies against the people who you ask to advise you, the professional liability side. I think what's interesting about that type of work is that it engages, if straight up and down commercial work engages linguistic and semiotic skills of analysing things, my type of work engages logical skills of causation and why have you ended up in this circumstance. So if you like to think through sort of argumentative causation, if you like to think of the sort of medieval rhetorical logic, that's the sort of thing I think is most interesting about the work that I do. In terms of the spread of areas, again, as Lucy said, commercial law is a term that is defined by its lack of meaning. It only becomes meaningful when you go down to the level of the sector. And so professional liability is equally a term that is an empty vessel, and into it you pour the liability of architects, the liability of surveyors, the liability of financial advisors. And so if you're interested in thinking about those sorts of sectors and thinking why is it that people invest their pension funds in things that are a huge disaster, you will be interested in looking at the liability of independent financial advisors, looking at the sort of people who offer investment prospectuses or prospectus or whatever. And that's my kind of area. And I think it's interesting. But then again, many people would say I'm not a very interesting person. So that's a judgment you have to make for yourself.
Thanks. I'm Thomas Cordrey from Devereux Chambers, and I also come from a slightly different perspective and perhaps even more impure than the perspective that Anthony's spoken from. But before I talk about commercial law, I'll just give you a bit of background about myself. So I was called in 2006. It took me a year to find Pupillage, so I started Pupillage in 2007 at Devereux Chambers, where I then got taken on, and I've been there practicing since. In terms of my history before that, I went to a state school, and then I did a law degree at Cambridge, and then I did what was then the BVc at BPP. I don't have any lawyers in the family, but it was something that I'd always wanted to do. I'm sure many of you will have been in that position of not being quite sure why you want to do it, but the career at the bar is something that has a great draw and attraction to it. I'm also a member of the Bar Council Equality and Diversity Committee. One of the things we do is we make efforts to improve access to the bar. We want it to be something that is not just restricted to certain segments of society. And also, more specifically, I'm part of the COMBAR Equality and Diversity Committee. So COMBAR is the Commercial Bar Association. Most areas of the law have their own particular bar associations. There'll be one for criminal law, one for family law, and the commercial bar is no different. So as part of that, I will attend law fairs. I may have met some of you before, and speak to you about what it takes to work in this area of law, which has already been described as being diffuse and does cover all sorts of different things. My own practice is a mixed one, so the commercial side of things covers insurance and professional negligence as well as general contractual issues, but actually I also practice extensively in employment law. So that gives me a slightly different view on the situation and a practice at the commercial bar. And again, it's one of the things that can be said about the bar is that there are no standard practices. You will find different barristers within different chambers who have a different mix of work. And I think that's one of the fun things about it. For me, I like having a mixed practice. The employment means I get an opportunity to do a lot more advocacy than perhaps some of my colleagues will do if they're purely working in the commercial sector. Since I was taken on as a tenant, I would say from the start I averaged a couple of days a week in court. That's great. It means that when I do come to do the commercial trials, I've got a lot of experience in doing advocacy in county courts, employment tribunals, employment appeal tribunal, and court of appeal. So that sort of thing is something you might want to think about in terms of what suits you, what suits your personality. Are you someone who loves spending time in the library, loves that attention to detail, the reading of the books, the drafting of the documents? Or are you someone who might like that but also might prefer a bit more of the advocacy side of things as well? In terms of those two areas that I've mentioned, professional negligence and insurance, professional negligence I think is great fun. My own practice, it tends to be surveyors or architects or solicitors. I particularly like doing solicitors' negligence. It's something where you get to delve into the life of the other side of the profession and see where they might have gone wrong. So factually those cases are very interesting. In terms of insurance, I always thought that insurance would be extremely boring. Maybe some of you would find it boring, but actually the factual issues tend to be a lot more interesting than at first sight they might appear. So a few of my cases have involved insurance claims coming out of riots, insurance claims coming out of an arson attack on a collection of vintage Bentleys, and most recently the case that I was led on that went to the Court of Appeal was all about legal expenses insurance, and a test case on when you have a policy of legal expenses insurance, whether you can choose your own lawyer, as the European directive says you can, or whether there is any restriction on that choice. So I think in terms of insurance law, you need a love for the English language, you need a love of an attention to detail, and also you need to be prepared to work hard when those cases come in. As has already been mentioned, commercial clients, they want to know the practical answer to the practical difficulty that they're in at that time.
Thank you. And I'm Tom Richards. I'm in my 7th year of practice at Blackstone Chambers, and I'm the real tail end Charlie because I only became a commercial lawyer by accident. When I was in your shoes, I wanted to do public and EU law because I thought they were sexy, which they are, if you're that way inclined. And to me, commercial law seemed a strange world of contracts and of large boats, which I didn't understand, and I thought I would never be able to practice in as someone who only had a GDL and he didn't really know anything about the law at all. It turns out that I was wrong, and I've ended up doing about 50% commercial law and 50% public and EU law in my practice. I can only really add to what the others have said about the joyous variety of work at the commercial bar, which is one of the most attractive things about it. For my part, I practice mostly in the commercial side of things, in civil fraud, in music and entertainment, and in sport. Just to give you some examples, I've been involved in a spate of litigation following the discovery of Bernie Madoff's Ponzi scheme. This was you may well have heard of Bernie Madoff, who was a great financier in New York. He ran what appeared to be a massively successful investment advisory business. It was, in fact, just a Ponzi scheme, and Bernie made off with all the cash. And since then, people have been trying to get it back, and I've been involved in that. On the music side, you might come across disputes, say, where the drummer gets kicked out of a successful band. Now, the drummer goes to lawyers and is very upset. And he probably didn't realise at the time that because he's been laying down beats for all those years, he may well own the copyright in those beats and may be able to claim a financial remedy from his former bandmates on the back of that. Also, and this will be a surprise to all members of the group, but they were carrying on business together with a view to profit. And so they were actually, and this is a real surprise to them, members of a partnership, just as solicitors or accountants were members of a partnership. Now, of course, they didn't have a partnership agreement. They didn't even have a partnership agreement written on the back of a fag packet, but the legal remedies under the Partnership Act may still be available to the disgruntled drummer. In the sports context, you can have a commercial dispute that arises, say, where one football club wants a permanent transfer of a player from another football club. But because of the difficulties of transfer regulations, they decide to structure it cleverly as a loan, to be converted in due course into a permanent transfer. So player comes on loan and club pays a huge whack of cash under this loan, much more than they would have paid for a loan at all, because they think that in due course they're going to get a permanent transfer. But the poor player gets homesick, wants to go home, and at the end of the loan period he refuses to complete the transfer. Club says we didn't get what we paid for, and the other club says, well, yes you did, we structured this as a loan for payment. And so in those circumstances, can the club get its money back? Those are the kinds of issues that I come across in my practice in the commercial side of sport. But commerce won't stay in its box either. I've said that I do public law, but it may be that you have a client which has a contract with the government. The government purports to revoke that contract, and it could be a huge franchise, for example, to run a railway. In those circumstances, you can't keep commercial law in one box and public law in the other box, because your client may have remedies not only for breach of contract, but in public law challenging the legality of the government's decision to terminate the franchise. So for me at least, the variety of commercial law is definitely its major selling point. How do you get here if you want to? I think that there's not much I can add to what the others have said. You obviously need the 3 R's, reading, writing and rhetoric, or advocacy as it's called in the modern era, and you need a high degree of, you need a really inquisitive mind, which is a great euphemism for being extremely nosy and interested in other people's business, because that is ultimately, as a commercial lawyer, what you deal in.
Tom mentioning drummers has just reminded me of a case that I did in my small insolvency practice as well, when I was representing a drummer who went by the name of Damage. And that was the only time I've represented someone by that name. And it made it somewhat difficult as an opening gambit in front of the judge to explain that in relation to this individual how responsible they were, and it was just unfortunate that they hadn't answered their statutory demands because they'd been touring with Westlife. So these are the sorts of things that get thrown up that you might not necessarily expect in the world of commercial law.
I wanted to add on something back of something you said. I went to a state school as well, and I didn't go to Oxbridge, I went to Manchester. And I think that it's a misconception. I think it was a misconception when I came to the bar, but it's certainly a misconception now, that you don't have to have gone to Oxbridge, you don't have to have had a very privileged background all the way through. You need, if you're thinking of coming into the commercial bar, you need to try and get first, or a distinction in your GCL. One of the two will do. If you haven't got a first, you need to try and do something else that will make your intellectual ability come through on the paper sift, which is a very blunt instrument, but obviously it's the only way of dealing with applications. There won't be a prejudice against you because you're not rocking up with an Oxbridge degree, and I don't think there's a prejudice on the basis of the fact that you're a woman or from an ethnic minority. I think the bar is very, 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 very merits based, and if you've got it, you'll get in. And when you're coming to the bar, you hear all the time, it's really hard, you shouldn't try, only a third of people get in. You should try. It's the best job in the world.